Hey guys, happy Wednesday. All righty. Looks like we got a few in here. Nice to see you guys. Let me go to Kevin. Let's start this off with a bang. Kevin Johnson, nice to see you. In recon since May of 2024, why did I have to do another adult function report? I know they are behind, but what happened to the other report? Okay, so your other report is in there, the one you probably did on initial. And because, this is my understanding, because that could have been a year ago, remember your function report from initial was your status quo then. That was your situation then. Very often we worsen, because a lot of our impairments are progressive or degenerative, and it's not just recovering from a quick surgery or something like that. Oops. I have this thing blocking my window. I just fell. And so if you've worsened, you kind of want them to know that. So you want to discuss specifically in what way things could be more favorable to you in terms of your case, not to your quality of life or whatever. So it's your opportunity to update them that things have gotten worse and how, by answering those questions. I know it seems like a lot. You're filling out a whole new form and it's kind of lengthy. I don't know that it would be a bad idea or damaging. Let's say there is an answer that is exactly the same as before. And I don't mean the checkbox answers. I mean something with narrative. And I think that might be rare if it's been a bit of time. I think something might have changed a little bit. But I don't know that it's terrible to say all the same limitations or all the same answers before, except, and then add it. Rather than recreating the wheel, I think that's kind of acceptable. Some people might beg to differ on that. I don't know. But I think that's acceptable because you're actually referring back to your old one and saying, that's still so. And here's what I got more. I mean, something could have happened in the interim. You could have plantar fasciitis, a new impairment, or certainly one that's progressed worse. Carpal tunnel syndrome on the right could now be bilateral, and you want to get that in there. So that's going to be less activity you can do with the other hand that maybe previously wasn't impaired. So I hope that answers your question, Kevin. I thought it was a good thing they were asking this for reconsideration. Maybe, I don't know if that is any, I feel like we get a lot of recon flips, but we also work on the initial and the recon. So it's not going to be necessarily an organic flip. And maybe that's why it's higher. But when I take on a case and we get denied on initial, I get appeal data information from my clients for the appeal that we are going to draft for them. And I also, once I get that back, because I don't want them overwhelmed with paperwork, I actually send them an updated activities data packet because we foresee that there's going to be an additional function report requested on recon by the SSA. But if there isn't, we can use it. I can't tell you how many times I see impairments that weren't described before, and now they are. So now I have an inquiry to make with my client, like, hey, I noticed you said this. Have you gotten that treated? Because sometimes, people are just busy or preoccupied with their disabilities and their ongoing daily struggles, and they forget to tell us things. So all these ways of getting more information are oftentimes a double check, or they function in two regards like that. Hi, Tara Denise, nice to see you. And Dimple, hi Dimple from Ohio. Okay, so Kevin's got another question. Good questions, by the way, Kevin. Thank you for these. If you get medically denied for SSDI, will you get the lowball SSI? Actually, if you're medically denied for SSDI, you are also been medically denied for SSI during that same period. The only time that SSDI medical denial doesn't also apply to SSI is if your SSDI window had already closed and they're only looking at a backwards period because your date last insured already expired. So the SSDI applies to that time period. But if you also had an SSI application in, and you have to affirmatively have one in, affirmatively, it's not presumed, and that screws up people sometimes, then the SSI, the calculation of whether or not you're disabled continues to the current period, one that doesn't include the SSDI period because that one expired, but you still have the opportunity for SSI under the current period. So, and whether the amount you would get for the SSI, while it maxes out at $967 in 2025 as the amount, the maximum federal benefit for that, yours could be lower if you have deductions that have to come off of that. That would depend on your living situation, any other income you might have. If you exceed the resource limit, obviously that can bar you altogether. But okay, I hope that answered that, Kevin. Good question. The disability determination applies to both any programs, SSDI or SSI, that are implicated in that period of time on that date. George, hi George. I remember you, George. Remember that? George is sharing that he will be 65 soon and is on SSDI. I want to settle my workers' comp case for $250K. Should I avoid the hassle now with penalty? Oh, gosh. When you're saying with penalty, George, I think you're referring to that you could have an offset with your SSD if you breach the 80% rule, which I'm not going to thoroughly explain here, but that will depend on what would you be breaching the 80% rule? What is your ACE, your average current earnings figure, and does the combined SSD and the prorated amount of the workers' comp that will apply to the same month that you get SSD in any given month, will that exceed 80% of your ACE? Higher income people who had a pretty high income the last 3 or so years, give or take, tend to have a higher ACE, and the combined two don't necessarily breach that. And they're not going to have any offset, but you don't know until those numbers are done. And sometimes you could try to do them yourself. You can call SSA if you can get through and figure out your ACE. You might be able to figure it out yourself. I've tried to ballpark it with people on consults. And again, it's only a ballpark and based on the information they gave me. So good question about what if I wait till age 67, because the offset doesn't apply when we are on retirement. Now, I don't know the answer for sure, George, so disclaimer here. So I would suggest talking to your workers' comp attorney, who should have all these things rolled up in their repertoire here. Once you turn retirement age, if you get a workers' comp settlement and it covers the backwards period, is that still going to be something that has to be considered for offset, since the months that the workers' comp settlement is applicable to, prorated over, could include months you got SSDI, and then the offset has to be considered? Or is there a way, because I know workers' comp attorneys, when they draft settlements, they do a certain language, at least this is what I was told by my workers' comp buddy in New Jersey, to prorate it all, so that, particularly if it'll help not have any offset. But what would happen if you didn't prorate it at all? Is this even possible? I don't know the answer. I'm just putting it out there for you to spend some time on, perhaps. But if you don't prorate it and you collect your workers' comp settlement at 67, does that escape the whole 80% rule? Or will the SSA be like, no, we got to prorate that? I always thought it was more of a workers' comp thing, because I know there was reverse offset and reverse offset states, and it was very whatever. And that's why I don't try to swim in that pool, because there would be too much for me to learn and stay on top of my game with Social Security. And since Social Security is the only one I actually care about, that's not happening. But something to think about, and talk to your workers' comp attorney about that settlement. I would do that. I just want to check one thing real quick over here, guys. Bear with me. Okay. Where are we at now? We're at Robert Sherbring. Did we meet Robert? I don't know. Sherbring. I'm thinking we haven't. But anyway, you're welcome. Robert says, hello and thank you. Oops. I can read it bigger over here. for all the information you provide. Oh, you're so welcome. It really is my pleasure. I am the parent of 2 DAC. Okay. Would a consultation with you be advisable so we are always ready for the inevitable redeterminations? When you say redeterminations, Robert, are you referring to CDRs for them, like medical improvement? I don't know that you need to buy a consultation, because I presume the basics, keep them in with relatively regular, if not frequent, because life goes on, depending on what their impairments are, whether it's needs treatment, make sure they're getting it. So it's always recorded how they are not improved enough to start working. Redeterminations, we're usually thinking of SSI, because they need to, from like childhood SSI to adult SSI. That's usually how I think of a redetermination. So I'm not sure if that's what you mean. But if it's just about, I want to make sure they have enough medical evidence in the rearview mirror for any CDR, I don't think you need a consult for that. You know what their medical treatment was. If it's the kind of thing that they have to consistently treat for, you're going to have those records, obviously naturally created. If it's something where it's just a chronic condition that treatment doesn't help, it's just something they're always going to have, they're going to their PCPs, obviously, regular doctors like we all do. And maybe once to be super safe, I suppose, if there was let's say it was an occupational therapist type of thing, if there's an occasional eval that they can do to confirm that the functional capacity they had before is the same now. I don't know that you have to do that. It might even be where you could do that if you got CDR'd, as part of your evidence that you're going to submit. But anyway, if there's something else I'm missing here that you're interested in, let me know. Dimple, do you think that with all the recent news changes, oh gosh, here we go, Dimple, you get me into things better off left unsaid, that will just cause the approvals to just take that much longer? I'm hoping to be able to continue working until the fall or end of the year. So Dimple, I think you're saying, and forgive me if you shared this before, because I know we've met before, you haven't applied yet. You're considering applying since you're working? Is that what you're thinking? Everyone's going to have their opinion on this, Dimple. We've had seriously longest delays I've ever seen in my 20 years. 20 years? Yeah. These last few. So I don't know that it can get worse, quite frankly. And now there's finally action being taken to improve it. I know people think that ripping off of the Band-Aid is the worst thing ever, but I just am not that kind of person. And everyone can have their opinions, and I respect everybody's opinion, but I don't think you let a sinking ship continue to sink. I think you take action and fix it where it needs to be fixed. I just did a video this morning because it came across my screen, an OIG report, and it wasn't the fraud law review that we do on Friday. So it wasn't about someone committing fraud. The OIG is also about waste and mismanagement and all that kind of stuff. And they had a March 24th report. And I'll just give you the header, but it was a review from 21 to 2023 of the manager to manager requests. That tends to be when a more difficult question or issue in a case comes up and a manager needs the expertise of a different manager who might be more experienced in that area or trained in that area, because they're not all trained 100%. They're not all trained 100% on everything. I suggest that probably we know far more about SSA than any of the on the floor people do, simply because it seems that they are usually taught a certain area well, but then don't know a different area very well. And that's why sometimes I think when you call to get information from the SSA, you might get wrong information because that staffer was trained other across the board basics, but not all the nuances and exceptions, or in just a particular area they're supposed to accept phone calls for. But you never know what someone's going to ask you on the phone, right? So in any event, there was a 57% failure of M2M process, where 50% of the cases were not processed properly. 57%. And I know some of them are probably mine or my clients when we've had some weird doozies. So sometimes it's a doozy that arose before I get involved, and it causes me to have to get involved because the person's not getting any logical resolution. So 57% of those, and it specifically says it has caused immense delay for beneficiaries getting paid. 57%. And that was from 2021 June to 2023 June, because they have those numbers. So, and the OIG's report was specifically to point it out, to say these controls need to be addressed. I go into a little bit more detail in the video, and I think it'll be out next week, only because I don't put out more than one video a day. So with the exception of this Wednesday thing, because I am doing the morning video on Wednesdays and then doing this. I wasn't going to, but it just, I don't know. I'm an old dog in new tricks, and I can't do it. I just know I have to do them all. Anyway, so I don't think you can't get much slower than we've had it, Dimple. So I think you don't really have to worry in that regard. It's bad. I mean, worry about it because it's bad, not because it's going to get worse. Because I don't know that you can sink any lower than we had gotten. So, my opinion, guys, working every day in it. Okay, Virginia, good morning, and good to see you, Virginia. If I have proof of my health with videos, pictures of me the last 4 years, can I take the proof to SSA office? I don't suggest you do, because pictures are not proof, actually. If they are medical films, the SSA doesn't even want those. They want the credentialed MD radiologist specialist, his report, because he is the one that interprets them, not an SSA person looking at it. Even an SSA MD, who is not a radiologist, and they generally are not going to be if they're doing stuff for the SSA. Our own videos, and I'll give you an example of, I tried this once. So it's not that your question's bad, it's just that it's not going to fly, and it's not going to be medical evidence. Now, by the way, if the pictures, you send them to your doctor, and your doctor puts them in the medical record, and then the SSA gets them that way, you just got them in the record. Whether or not they're going to put any of the weight on that, they shouldn't have to. It should be what your doctor ends up discussing about them. But that's a way to get them in if you want to. You get them in through your doctor. The example I was going to bring up was, this is a long time ago, but it helped me learn, right? I had a early onset Parkinson's fellow, and it was a kind of a traumatic case to me. His family had built it was like a rope. I don't know what room it was in, but it went up to the ceiling. So if he fell on the ground, or for whatever reason was on the ground, he could slide over to, and he couldn't get up because his condition had gotten that bad, and it might have been intermittent. I don't recall. I mean, we're talking almost 20 years ago, but it was a rope so that he could grab it with his arms, which I guess were better than his legs, and then assist to help get himself back up to his feet. And they sent me a video of it. And we were waiting for a hearing. So we were going all the way to hearing. And the judge actually called me, I think, to discuss an on the record award. And so we had a little conference, and I told him I had this video. And back then you couldn't, I don't even know if their system would take a video upload. So, but I asked, and he said, no, we really can't, because people could fake that stuff, Virginia. You know what I mean? Like, there's Photoshop. Have you looked at Reels lately, guys? The thing that comes up, I don't know even what app is this on, Facebook or whatever it is. And it's like, they have it's cool sci-fi and it's cool special effects, but I don't even look at them anymore, because it's like, someone's artistic license. I think it's great, it's fun, but no, I'm not watching, guys. There's like thousands and thousands and thousands. It could be a big Loch Ness monster coming into your backyard from your little pond. I mean, and it looks real, for those of us that are not Photoshop experts. But anyway, so Photoshop is going to, or I don't need to call it a name, but anyone could doctor something up. So that's not going to fly. That would be layperson stuff. But again, if you have good pictures, and sometimes clients send me like their swollen feet or whatever, different pictures. I've had privates that had a problem sent to me. I did not send them to the SSA. But that's something that you would be sending to your doctor because it's part of what he should be reviewing, particularly if he's not having you strip down. Or the day you get there, that swelling is gone, but you want to show him what happens every third day. That would be a good idea. And then that might actually get into the record if he, the way they put him in. It's going to be up to your doctor, though. But yeah, the SSA doesn't want layperson photos or videos, generally speaking, except for your photo ID to prove who you are. All right. I hope that answers the question, Virginia. That was a really good question. Scott Gallagher, nice to meet you. How much weight does an ALJ put in a consultative examination? That will vary to the extent that there are judges and consultative examiners and consultative examination reports. Because if the consultative exam is not consistent with the rest of the record as the judge is finding it, they very often will say, I'm not giving this much weight because. And if it's a consultative exam that is not in your favor, that's a good thing, right? Other times they will say, well, the consultative examiner said blah, 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 and that supports. So it's kind of going to be whatever he wants to end up being in a sense, whatever his end desire is for awarding or denying. Although I'll hedge that with saying sometimes I'll see a denial when he gave much credibility to a CE examiner, one part of their thing, like let's say the part that says the person can't balance more than occasionally, but then he held them to a sedentary job because you don't need to balance more than occasionally. So while they were limiting the balance like I wanted, they didn't limit the other things that I wanted. So they can kind of cherry pick at times too. So it's almost like you can't speculate on that. It's not gonna do you any good. But you always want a CE exam overall, arching. You want that CE exam that is very, very limiting in all the ways that matter to your case. And every case is different, right? Because we all have different jobs. You have to prove inability to do past work, and that will make a big difference amongst the various workers because everybody's jobs are so different. Thank you for that question, Scott. I appreciate. Amita. Hello, my case has been remanded due to ALJ's failure to reconcile the DOT with VE's testimony. Job used to deny is also no longer used to deny as of last year. Higher chance for approval this time? Yes, I'd say there's a higher chance because the job used to deny the ALJ's failure to reconcile the DOT with the VE's testimony, that's easily remediated. Job used to deny is no longer used to deny, meaning it's one of the jobs they eliminated, maybe? Wow. Because they have to come up with a different job. So in that sense, you are getting a slightly higher chance of approval, but it will depend on so many other factors too. Are there other jobs? And did you, between your old case and your new case, are you going to be bolstering that evidence? Look at what was weak according to that judge's mind. This is what I would do. And then go to town on strengthening that evidence from a medical perspective, not just a claiming perspective, if it's a medical thing. That way, when you go back to them, you've plugged up that hole. You fixed that inefficient piece of your case that is now better. Those are the kind of things I do, as well as just consistently going back to the doctor and keeping everything going that was suitable anyway. Okay. I hope that helps. All right. This is going to be a big fat no, Scott, but can you look up a judge for me and tell me if I have good odds? And he's giving the name of the judge. Scott, you can look that up. I don't even know what the website is. Somebody shares it though. I don't look at those things, and here's why. to me, I have a duty to work up all of my cases 110%. And I know for a fact that being human, and I've seen other people do it, and I don't want to give myself the risk of doing it. I'd like to think I wouldn't, but I can't say that. We all get tired. We get overworked. I've seen people go forward with sloppier cases because they had a high rated judge that, he had a higher than the average of win rate. So they thought they could, I don't have to bother with that little piece, that piece, that piece. Well, then when he denies, because it still has a denial rate, now you don't even have that appealable stuff because you slacked on it. You don't even have it there for appeal. So, and then other times, I haven't seen it, but I've kind of heard scuttlebutt about it. If one has a low awarding judge, they practically give up. And sometimes they head in there with an attitude problem because they think they have a jerk of a judge. And I don't think either one of those approaches are right. And so there is no purpose to me to know the win rate. When I first started, I was like everybody else, looking it up and, oh my gosh, then you're getting all like, look at that rate and blah, blah, blah. And that was when the rates were arguably higher than they are now. I just stopped doing it because it was a waste of energy. And what if it affects my balls to the wall attitude? I don't want it. You do all your cases as strong and with the same methodology, and you get the highest win rates. All right, let's move forward. So I'm not going to look it up, Scott, but you can look it up. It is out there. I don't mind even trying to find the link for you. Maybe I'll try to do that after this is all up and done. So just check back maybe in the comments under this live Q&A when it becomes a replay, probably later today. I think YouTube does it automatically, I think. Dimple, okay, she's clarifying. She's having trouble meeting her work requirements and is trying to hold out until I can draw from my 401k. Wow. Because you can't sustain, you don't have savings, right? Aside from your 401k to buy you time. Do you live in a state? This is not really my forte, guys, but some states have like state temporary disability for workers. I think it's paid for by employers. Not all states have it. My state doesn't have it in Pennsylvania, but New Jersey does, a state that I'm heavily involved with. And then all the other states that I do, it's mishmash. Sometimes people will get a few months of state disability, and that's when they're, as soon as they stop working, and then they, of course, budget down, so looking for the long haul, but that buys them some time as they're getting their SSD claim going, at least getting it strategized. And then, there are other reasons of whether or not you're going to file as soon as you stop working, or if you're going to strategically wait for a greater chance of winning on initial if you wait. But that's a case by case and very specific kind of evaluation that we do. And Dimple, just remember that if, sometimes we can work part-time under SGA and then we can earn a little bit and file our claim at the same time. Just don't forget about that option. So look into that if that's something you're interested in. Hello, Furry. Hello, Christina. Nice to see you. And Trish, good to see you back. Virginia Part 2. I always went into the ER for them. It was documented of my falls for leg going out. That's good. That's good, Virginia. A lot of times people will say, I fell 3 times last month. And they're saying it 9 months later at a hearing. And there's no record. There's no record of it. And the ER is probably a really good thing because if you do fall, you could have a cracked bone in there someplace from a fall, right? Any of us, particularly if we're not super young. The other thing people do if they don't go to the ER, and it might not be as good, but it's better than nothing, is they immediately notify their doctor. And they might even go in to make an appointment to be checked out. Or they go to urgent care. So, you know, there are other ways. And then the lowest bar, aside from not doing anything, is somehow getting it into their doctor's attention without a visit. Whether it means you put it in your portal and say, "Doc, I fell today. As I told you last week, I fell last week too. Like I'm falling more, blah, blah, blah. Can we address this? Can I have an appointment or super fast? Blah, blah, blah." Getting it in there. Everyone can pick their own way. You know, you're not going to have as much. If you have a ER visit to get checked out, they'll probably do an x-ray. Particularly if something hurts. Maybe not if nothing's really hurting, but you just want to get checked. So I think it really depends. It's kind of like having a little car accident. They always say, go get checked out. John Calamus, nice to see you. Should I wait until I get an ALJ hearing date to get all updated medical documents to send to the hearing office for review? Thanks for all you do. I find all your videos and updates to be a big help. I'm so glad, John. I would not wait till you get a hearing date. Oh my goodness. I would have been doing this, first of all, on initial and recon. First of all, if you, and it frustrates me that if you're pro se, you cannot see what the SSA has and what they failed to get specifically, date by date. But that being said, after recon, when you've applied for an ALJ after you've been denied on recon, there is a measure of assistance the ALJ does to help you get the medical records. They send you a request, 46, 31, 32, 33, perhaps, asking for all the updated medical stuff since you actually put it in your appeal for the ALJ hearing. And they will order them. However, and I come from the side where, of course, the person has a representative, so we're getting all the documents. They're not doing it. They're not really doing it when we are there to do it. And that's the level that starts at. But, I would get, I mean, if you've only had one doctor visit from a new doctor since, would you order that now? Maybe wait until you have your next appointment, a little bit. And if you have a portal, that's great. I'd get those too. But no, I wouldn't wait until the hearing. First of all, sometimes they take months to get them to you. And now you're past your hearing. And you also have, I mean, not that I would go by this because this is way too close in time, but you also have your 5-day rule. 5 business days before your hearing, you have to have all your evidence in, or else at least apprise them of how diligent you've been about getting it if it's late. And that letter's got to be in before the 5-day rule. I would be getting stuff way earlier. And then re-asking for any updates. Because you're the one that's going to know. I got something 3 months, like on this day, let's say March, what is today, 26th, and then you get a hearing date for July. You have, there's a few months they don't have. I get them what they don't have. Then I would probably every couple months get them any updates. And anything that's really critical, like, God, I got a new MRI, and you look at it, those things you can get in earlier. Who knows? You could get an OTR if you have a little really strong evidence in before hearing. So I wouldn't wait. The more time you give them to look at it and to organize and see it and consider on an OTR maybe, the better for you. So I wouldn't wait. Virginia, welcome. Kevin, my orthopedic doctor says I need surgery. Is that good or bad? Kind of nervous about knee surgery. Oh, I get it. Yeah. I think if you're a surgical candidate, it shows it how severe the knee is. So that's good for your case, not for your body. So the fact that he thinks you need surgery, and that's documented, I think that's favorable to the severity of that knee. Okay. Amita, you're welcome. Lauren Blackwell. Nice to see you, Lauren. Thanks for being here. I have seizures 3 to 8 or more a week, along with severe migraines, both of which I'm seeing a neurologist for. She states on the SSI paperwork I have 4, marked and moderate. How is this weighted? That will depend. The judge makes the decision on how it's weighted. it's not weighted as a matter of law, because if she's found to be not credible or her opinion conflicts with her medical records otherwise, that's one of the dangers of it. Did you send her SSI paperwork? Because you say market and moderate, and those are things on an RFC form that is usually it's a SSI form that they use with their own internals usually. Sometimes they send them to a doctor, but because doctors normally won't fill them out, they probably don't do it so much. But with that language, it's telling me that it's something, I'm guessing if the SSA sent it to her and she answered that way, I think that's better than if you sent it to her and she answered that way, if you get my drift. And for market moderate, and it really depends on what we're talking about. It's very specific. Market is good. But there's extreme after that. But it really is going to be very specific to your impairments. If you described how many days a month you would be bedridden with those migraines, that would be kind of important. Oops. Why is it doing that? I don't know why. Okay. But anyway, I hope that answers. She's obviously very kind doctor to even fill it out at all. So I think that's really good. Those are a dime a dozen. I mean, not a dime a dozen. They are rare. All right. Dwayne Price, 60-year-old Texan. Hi, Texas. Howdy, y'all. I've been awarded finally at initial. Woo! We like to hear that. It took 16 months. See, guys, the delay the last few years is crazy. 13 months of back pay. Party at my place soon. I want to be invited. If the house is a rockin', don't bother knocking. Just come on in. Dwayne, I'm so happy for you. That's really great. Yeah. Did you just get like awarded this month? I'm trying to think if did we talk about this? Yeah, some of them are pulling through now, where they were like lagging before. So that's really cool. Hi, James Barlow. Here's a question. They went back 3 years for my SSDI. Okay, probably good. The judge found me disabled from 2020 to 2023, but don't start getting paid until October. Is that considered overpayment? I have no idea. There's got to be facts. God, can I talk? Facts that you don't have here that are relevant. He found you disabled. Now here I'm confused. 20 to 2023. What about 2023 to 2025? Where are we at now? And you say you're going to start getting paid in October. Is what an overpayment? October is far away. So there's something going on here. Oh. Did he find you? Now I'm just throwing this out there. 20 to 23, but then found that you were covered and that you were again disabled, in which case you're not going to get. I don't know. There's just not enough facts here. I'm sorry. Sorry, James. Dio, good to see you. How are you? Nice to see you versus just post back and forth. Will an ALJ consider medical evidence past DLI for SSDI if there is a concurrent filing? I'm not sure if I'm going to get this question, Dio. Will an ALJ consider medical evidence past the DLI for SSDI if there is a concurrent? They say no, that the evidence of today can't be used for last year, which might have been before the DLI. However, I have made the argument, if it's been very close in time, and usually, in fact, I'm going to be making the argument on a mental case that I have now. We're not scheduled for hearing yet, but we have appealed for hearing, because The person went into psychiatric emergency like 2 weeks, like a month ago. And in about a week is going into a longer term residential psych inpatient. The DLI is September of 2024. I've already submitted the argument, because sometimes I do them before they're actually going to be seen, just in case I get eyeballs on it, that this is just illustration of what he was going through, and he finally crashed. This occurred when he hasn't worked in 5 years or 4 years. So he came to this crisis while having a very genteel, structured environment where there is no work pressures. Imagine if there was work pressures of even like cashier, which I consider that a stressful job because you're dealing with the public. But some would argue, oh, it's a low stress job because it's low skill. No. I don't agree. So I am making the argument, Dio. So I don't think you shouldn't make it. I can just say that they will often say that cannot be used for blah, blah. Because part of me thinks this way too. Logically, we know what happens, at least if it's not like way, way later, is a buildup from before. But also, I think it can help a judge realize the realities of a severity. And then he or she might be pushing to find and pick out all the things that kind of like little crumbs in the past, in the relevant time, and find the connection that they can to legally support it. So part of the job, I think, from my perspective, is to get the judge to want to award, to think that it's right to award if he can find the legal, and that's not just wear your emotion on your sleeve and he'll fall for it. No, I don't mean that at all. I mean showing the evidence that common sense would say clearly this has been a problem for a really long time, and based on the other evidence where the person wasn't totally imploding, but it's leading up to it, and showing him what's real, and can we find a legal way to get there, what we know to be the right thing. Because if there's no legal way to get there, he still can't do it. But if there's a legal way to do it, you want him to be able to find it, and be inclined to go that extra yard. So just my inner workings when I do these things. Patsy's Place. My daughter got her SSDI. They take out Medicare Part B. Yep. And it really lowers her monthly payment. Yeah, by about $1.85. What is an alternative? No insurance. People can reject it, but that's probably not wise because then you don't have coverage, right? So I can't give you an alternative. If she is low income, because it's going to reduce her monthly income. It reduces every single person's monthly income, just so you know. Your daughter's not alone, including retirees. If her income is low enough where she's considered poor enough, she can potentially get Medicaid as well as Medicare. It's like a concurrency. And what's nice about that, Patsy, is that the Medicaid will be primary. Medicaid fills in what Medicare doesn't, and may cover copays and deductibles and premiums. Find out. It's if she's low income, it might just be the case. So look into that. It's not my forte. I just know it happens to exist when it applies. I can't say for sure exactly when. Okay, but it's designed for those that would be eligible for Medicaid, and I think it might be a recognition that. And I'm not sure, there might look at all the various ways, because it is a shame if someone doesn't have SSDI, they get Medicaid. Then they get SSDI that puts them $1 over the threshold of Medicaid eligibility. Well, now they're really kind of getting screwed, right? Had they just been on SSI, that wouldn't be the case, but because they were a worker, they got SSD. So I don't know much about it, but look to see if there's some sort of sliding scale too. Or am I pulling that out of my butt? I'm not sure. But look, again, I'm not a Medicare expert. I try to steer clear, and certainly not Medicaid because that varies in all 50 states, but worth looking into that maybe there could be that Medicaid as well if she's as low as income as you think she is. Okay. Also, what some people do is work while they're disabled pursuant to the rules, and they buy enough to bolster up, maybe make that extra $200 a month to cover that Medicare premium. Some people aren't obviously capable. I don't know what your daughter's situation is, but anyway, just another idea there. You're not bound to be constrained by solely your SSDI. The SSA does encourage, and it's not a trick. You just got to stay within the rules. People to get out there and work. Think about it. All the part-time workers, they pay taxes too, right? Can a mod delete my question? For sure. What do you mean, Scott? Yeah, if somebody said something, we had someone last week being a Weisenheimer. I know when I was on Jonathan Ginsburg's show once, he had somebody who was saying some nasty things that were very offensive to him and to me. And so, of course, they turned him off, which is what I would do if I saw it. S. Lewis, good to see you, always. Doc's note from a visit is inaccurate. Oh, yeah. But note is already an established record. Should someone still request record amendment with hospital? So it's a doctor in a hospital, Lewis? If record is changed, what impact on case? How to navigate? Getting them to change it's probably going to be difficult, but it can happen. You have to make the request. I understand. I think it's under federal law that they have to consider a request if you do it in the manner that it's supposed to be done. And you would check what that would probably be state regulated. They do not have to change it, but they have to note in the record that you pointed out what you say is an inaccuracy, and they will either change it or not change it. But they have to let it be known that you said it's inaccurate. That's my understanding. What will happen on the case? That will depend on how the judge interprets it and whether it's even material. Some people get very aggrieved about inaccuracies in their medical records, of which it is very prevalent. But they get aggrieved at ones that are not material to their case because they don't necessarily know which ones are material to their particular case. It aggrieves me when records are wrong, even when it's not material. But maybe you want to pick your battles too. Is it material or is it not? Sometimes it is material. Like, let's say sometimes they put out things that are, they didn't even have to put out. Like, he said he took a trip around the world on horseback 6 months ago, last summer. I'm pulling this one out, but I do see things about vacations, and it makes this person sound very fit and able and everything else. And it turns out that the person didn't do that, or no, I got the Oculus and I watched a virtual trip around the world, and it took me 3 months because you do an hour a day because that's all I can do with sitting and standing with the Oculus. Oculus is one of those virtual reality headsets. I'm just giving you an example of how they'll just say he went on a vacation trip around the world, and now suddenly a judge is going to say, really? You're confined to a wheelchair and have dialysis 5 days a week, and you went around the world? And now he's not going to, hopefully he would see that that's got to be a mistake, but you don't know, So that to me is material for your case. Now, if they say he had 2 x-rays in the last 2 years, but in fact you had 3, and the 3 are actually in the record, then his error is innocuous. It doesn't matter because the 3 x-rays are going to be in the record, and his error, is not going to matter. So it really depends, Lewis, on I think about the battle you want to make. Is it material to your case or is it not material? If it is material, I would put in a request for it to be changed. Yep. And again, how each hospital or state, rules apply is going to differ, but you do have a right to ask for it, and they have a right to do it or to not do it, but to make sure it is known that you asked them to. You said it was inaccurate. Hi, Furry. Yep, 1620 is SGA this year, Furry. Dominique. Hello, how long does it take to see a judge for an appeal from a denied reconsideration, and what are the chances of winning? Well, if we knew those chances of winning, Dominique, I would have a crystal ball and I'd be making $1 million. There are no set chances. You know, the average amongst everyone, represented and unrepresentative, is whatever it is. I feel like it was recently at like in the 40s. Does that sound about right, everybody? Mid 40s, maybe? If y'all have been like seeing that on any kind of waterfall chart or in other dicta someplace else. And the time frame is very variable too, Dominique. I see mine stretching out 6 months now from the time we request a hearing, at least. Back in, and that was when it had been shorter and then started getting longer. Maybe even, I'll have to see because everything is so changeable, but they are getting longer, but not as long as they were like 10 years ago, or and up until like 19, we were looking at 2.5 years to a hearing after you appealed from reconsideration, Dominique. So then they hired, I understand, ALJs and maybe decision writers. And by 2019, so that happened in maybe 2018, but 2019, all of a sudden it was right before COVID. I remember I had a appeal that was scheduled for a hearing within like, I think it was 4.5, 5 months. And that I considered very fast at the time. Now it's maybe stretching out again. So, but that was kind of great. Double-edged sword, though, which I've mentioned in other videos. Those speedy hearings are not always to your advantage, particularly if you don't have a strong case. You've been denied twice. What have you done to fix the strength of your case? So use your ALJ waiting time period to get more treatment, get more diagnosis, get whatever is missing from your case to give a judge a reason to not agree with them down below. Virginia. I do try to be sincere. I'm very immature, Virginia, but I thank you for appreciating my immature humor. Amita. I hope I'm saying that right. What is a significant number of jobs in national economy ALJ can use to deny? Job 1 had 11,500 jobs, in that order, removed last year for use of denial. Job 2 had 7,000 and job 3 had 7,500. They don't give us that answer. I would say those are on the low side. I don't know if that's low enough because they don't give us that. They've never carved that out. They refuse to. And did they carve out nut sorter because there's only 11,500 left? Or is there really not those left anymore because they don't use people to sort nuts and they use machines? I don't know the answer. So it really depends. I will say that I generally don't fight my cases on the numbers because they're given so much leeway. I think it's a waste of the hearing time or a post-hearing brief to argue, with a judge. I don't think 75 is enough to be counted. And now that VEs have a wide range of sources that they can go to besides the DOT, I think that might have changed as of, when did they make the decision change? I think it was last year, but came effective in January, maybe. It's not the battle I picked because it's the RFC business is really the battle one has to win, because he could just up your RFC to get more jobs, and you could say, well, not if my evidence says otherwise. True, but there's a lot of gray areas that they can really tweak. Not to say numbers aren't important, of course. And yes, I would argue that those are not high enough because you can. I probably wouldn't spend time at hearing arguing with a VE about it. I would probably use that at appeals counsel. And they probably won't care. They might reverse it, but usually on a different basis. Oh, Virginia's going to go airbrush some t-shirts. May the Lord bless you and your family. Have a great day. Oh, thank you. I appreciate that. I could use all the blessings I can get. Okay, Lauren Blackwell's confirming that the RFC form her neurologist got, right? Lauren, neurologist, was from the SSA. That's good. That's better than you just pulling one off the internet and sending it. I'm glad to hear that. So that sounds good. From what little I know about it, sounds good. Dwayne. Yeah, Dwayne was just awarded yesterday at step 3, closing Arkansas. Moves back to Texas last week. Oh yeah, that was 2 different places. Overjoyed. Nice super chat headed in your way. Oh, that's sweet. Yeah, so he waited 16 months on initial. Was that it, Dwayne? And it came out in March 2025. Glad to hear they got through that little hump of you not having an adjudicator, probably. All right, James is giving a little clarification here. Won my case August 8th in 2023 for SSDI. The judge said they were going back to 2020, 2021, 2023. Where's 2022? They gave me 3 years back pay. Okay, that's awesome. But they started paying in October of 2023. Yeah, because no. All right. So James, you won your case in August. By the time they figured it out, they started paying you in October. That's not bad. I mean, that's, 6 weeks, 8 weeks, whatever it is. Started paying you in October 2023. I assume that means your monthlies going forward. Did they send you your back pay for those 3 years? The back pay would be an underpayment until they pay it to you. Now you're no longer underpaid, in a sense. Not that we actually look at it that way, because you just had the adjudication right before, so they need time to pay it to you. But if they didn't pay it to you, they would now be in underpayment status, the SSA. And I hope they have paid you those 3 years. Let me know if they didn't. That would be BS. Hi, Big. Q1. Q1. I don't know what you're talking about there, Big. Sorry. I don't want to confuse anybody. Okay, Furry is talking about, I'm going to point this up here, Furry, so people can do their due diligence. She's sharing that QMB helps also if you do work under SGI low payment for Medicaid. Look into it, guys. I'm not going to be able to, but you can, particularly if you're, concerned about those Medicare premiums, copays, and deductibles for a person that's on a low SSDI. Look into, see if Medicaid might be concurrently available. Lewis is saying that the errors in the medical records were very material. Then I would hop on that, Lewis. I really would. Kevin asked, you going to do another live stream with Jonathan Ginsburg? Probably would be my guess. I haven't talked to him in a number of weeks. He's busy. He's having fun too. He's got little grandkids and he lives close with his kids. Like, they all live in the same area. It's a very enviable, lovely family that all kind of live in the same area. And not to get off topic, but I really feel like one of the detractors from quality life as we get older and for younger people is that everyone's so transient. Kids move far away from their parents. Sometimes parents move far away from their adult children. That happened to us. And then when they got sick, they are not within a day's drive for us to help. And some of them have now passed, and not all, but it's a problem. So, and it's heartbreaking. So, yeah, I think it's great how Jonathan has handled his family. He and his wife, Kira, I think her name is. I might be seeing Jonathan tonight because we have a monthly, very small, intimate Zoom that I started, I think, like 4 or 5 years ago, probably after COVID, where a few of us get together and just talk about any SS issues that we want to talk about. So it's very personal, casual. I mean, we're making jokes about starting to have wine with it, like, because it's late in the day, and that starts at 5 o'clock. So this is a busy day. But if Jonathan did say he was coming, but I don't know if, people's schedules change on a dime and all that. So it's very informal. I don't know. But if you do see him, Kevin, you can ask him. Just say, Stephanie says she'd be happy to come on again. And I'll reach out to him too. Oh, thank you, Christina. Please don't forget to share the live video with your friends and family. Oh, that would be great. And to like, share, comment, and subscribe. Thank you. She's a great cheerleader. Thank you, Christina. Dominique, having chronic pain in the back and knees, also being in a pain clinic, seeing a specialist will help your case. What you're having is important if you're complaining about it to the doctors and getting treatment for it. So if you're complaining about chronic, pretty severe pain in your back and in your knees, then they can do the diagnostics. We're going to actually give some objectivity to those claims. And you want your diagnostics not to be 10 years ago, but to be in the last year, right? Pain clinic can be important because it's usually a continuity thing. It shows that you need to have that continuing treatment for pain because the pain is continuing. That could be like injections and such. I mean, sometimes it's opioids, and then they have you under a opioid pain contract, usually. And specialists, yes, very good point, Dominique. Specialists are so important. Our PCPs are important, but when we have an impairment that would normally be treated by a specialist, because the PCP, the family doctor, the primary care physician, is not a specialist in that area. He's more general. To me, he's like the captain of the ship, and all the little expert little crew members that know their specific thing go to town on that specific thing. So he can steer you, refer you, and all that, and also give you general exams and take your complaints every time you go to him for all those areas. But the specialists, because they have higher credentials in that area, I think they are given, all else being equal, more weight, assuming that their records are consistent with their opinions stated in their records. A specialist is definitely helpful. All right, George. George is up. What is the best evidence for SSA or ALJ to get better chance of approval? X-ray, CT, MRI, or EMG? Depends on the problem, right? I tend to think the X-ray is the lowest on the mark, but all the other ones depend on what the impairment is. But I like, if someone ever has musculoskeletal, I'm always like, well, hopefully they'll get you an MRI. If someone has something that could be nerve-related, EMG, right? Carpal tunnel. X-rays show certain things, however, but I don't know. I just have this thing about the other ones. I think they find more things that X-rays don't show. So if you have an X-ray that's negative, you could have MRI that's very positive. Spinal canal stenosis, or a nerve being impinged or compressed in your spine. So go high. Hi, Janelle. I know we chatted before. Is it normal to wait longer than 5 months after a hearing, Massachusetts? I think I told you this. Didn't I take it back? I hope it's stuck. I think that's pretty long. It's not that I haven't seen it, but that's on the longer side. That's on the longer side. So sometimes you'll see it long, and then they'll ask for a supplemental hearing. And they were getting an ME involved. Or they have a very overburdened pool of decision writers. So your ALJ may have made the decision, but the decision writers haven't gotten to it yet. Or the ALJ went and saw additional evidence that you're unaware of that he did that, because you can't get in there. If you're pro se, you can't see what he did, I don't think, right? If you had an attorney, they could get in there and see that he sent out a request for interrogatories from a some sort of expert on your case. Can't really say, you know, which one of those that it may be, but 5 is longer than shorter, for sure. And I'd say longer than average. Trying to see if we got any more questions. I think we're good here, guys. Is there any more questions? Usually we're backed up. Well, if I see if any more plop in, I will go over them. In the meantime, Chanel said that she's terrified because her lawyer said that they are at the court's mercy. Well, that is true, really, of any court, right? You're going in there to have a fact finder determine what facts they believe to be so. And at some point, you just have to cross your fingers and say a prayer, right? But you've done your due diligence. You have a lawyer, so that means that someone with great incentive to prevail is there. So that's good. While we're seeing if anyone has another question, I was talking to a gentleman today. I had done a consult with him a time back, and we were just chatting today on a related issue. So I gave him a buzz back when he emailed me, right before we started here, actually. So I think I'll do a video on this, but this really pertains to people who, because he said, I think there's so many, he goes, I know so many people that do this and they're concerned. And it has to do with someone who's on Social Security disability and they sell, you know, personal items and they're issued, let's say they do it on eBay and they're issued a 1099K and they're concerned about the SSA finding the earnings and saying they're earning too much outside the permitted amounts of SSD, you know, earnings while you're collecting. I can't go into the details here, but I told him I think I will put something together because some of the things that I think would be relevant are you selling personal goods? That's not really work activity. Or are you buying things and reselling them, in which case now it is kind of like a job. Big difference. And then you always have to remember that it's self-employment when you get something like that. And you are not going off your 1099K because you're going to subtract every expense that went into making that 1099K amount. And you probably do have to be breaking it out month by month. So just remember to keep all your records really fine. And that's if you ever get to the point of having to prove that, because if it's not considered work activity, you're not going to have to. But you want to have the documentation in case they assert otherwise, so you can prove otherwise. Okay, so I think we'll go into that at some later time, because he said that he had a similar dilemma, and I think he's going to be totally fine. And we talked about the reasons why and all that, and you know, duly filed the tax return and all that. But that is something to think about, you know, that you don't necessarily have to be afraid about selling things. I mean, if you sold your house and made a profit, that's not going to be work activity, right? That cancels out your SSD. Pardon me, I gotta take a sip. Hi, Phantom. I think you're asking me for a medical piece of information. I'm not a doctor, so I can't do this. What does this mean? And it's a bunch of letters. Fully active, able to carry on all pre-disease performance without restriction. I don't know what those letters stand for. I don't know if your doctor's saying. Basically saying you got a good bill of health if you're a cancer patient in remission. So that's good, right? But again, I am not a doctor. And I am far from a cancer specialist. I steer clear to the best I can. Anyway, I think we're good, guys. I don't see any more questions. If anybody has it, pop it in now, or else I'm going to cut loose. Okay? Anybody? I'll give you a couple minutes. Meanwhile, I'm going to check in a couple things here. Oops, for my next thing that I got to do. I'm actually meeting with a Medicare group in a little bit, because my people generally need good Medicare information when they decide after they become eligible for Medicare, after 2 years of collecting, 2 years worth of collecting benefits, or retirement. You know, what all the ins and outs are, what they need, what they have an opportunity to get that they won't be able to get if they don't get it in that window right when they become eligible, and they're not going to be underwritten. So we're going to go through all of that. And, you know, I always try to keep some trusted Medicare people in my sphere, because, you know, I really don't want necessarily my people feeling that the only thing they have to call is the number they see on the TV screen in October when, you know, JJ is doing his thing. Because they're just commercials. I don't know that you're going to get a company telling you, oh no, that other company would be better for you. I just don't see that happening. Or, oh, you want that Advantage plan, not that other plan. Or, you know, even though it might not be all that. So, or which one would be better in your zip code. So I look forward to that conversation. I don't think it's going to be too long. And then later on, we have our colleague Zoom at 5 o'clock Eastern. So I'm looking forward to that. And it's just been a long day of meetings. So tomorrow will be more of a in the trenches again. But anyway, I think we're good, guys. If I missed any question, feel free to maybe post it. I don't think I missed any, but if someone plops in late, if you send a good question up to maybe put it in the comments once this is posted as a replay, and I'll try to grab it if you do it quickly. Otherwise, you're going to have to wait till next week, okay? All right. Have a great one, guys. I'll talk to you later. Bye.